Hey, Ben McClintock here from defendingutah.org, and today we're going to be getting back to basics on the fundamentals of proper government. And this is a presentation by Dr. Scott Bradley. But before we get into that, if you like what we do here, please click on the subscribe tab and the subscribe button and click on that bell to make sure you get notifications. And if you really want to be a part of the solution, if you want to be part of a community, build community, and to be able to preserve liberty and restore lost liberty, please go to defendingutah.org and become a member today. This presentation that we're going to share with you now is from Dr. Scott Bradley. It was a presentation that he gave at a recent Liberty Coalition conference in southern Utah of great liberty leaders in liberty in the liberty movement here in Utah. So it's important for us to get back to basics. A lot of us are just waking up, or it's always good to get a refresher. And Dr. Scott Bradley is always a great guy to get these basics from. So without further ado, Dr. Scott Bradley.
Scott Bradley here. I've prepared this little presentation to discuss the fundamentals of liberty and proper government. In this presentation, we'll discuss the basic principles of American federalism. These are essential elements which are critical to restoring and preserving liberty, and to the unique Americanist principles of proper government. Let's spend just a few minutes talking about some things that Thomas Jefferson brought forth. He's a great icon of liberty in the establishing and founding era. Thomas Jefferson was the principal author of the Declaration of Independence. We're going to be referring to some of the things he wrote therein. But at this point, let's just talk very briefly about the ideas that he brought forth as he was inaugurated for the first time as President of the United States. In his first inaugural address, he said, "The Constitution on which our Union rests shall be administered by me according to the safe and honest meaning contemplated by the plain understanding of the people of the United States at the time of its adoption. A meaning to be found in the explanations of those who advocated, not those who opposed it. These explanations are preserved in the publications of the time." That will be the source of the information we'll go to be able to discuss these basic principles of liberty and proper government. We go back to the American founding era. And I think therein we find safety for how we might, again, restore what we had in the beginning. Let's begin by bringing up principle number one. Logical time to start. The source of our rights is what that includes. In the Declaration of Independence, written in 1776, we read, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights." So, principle one, God is the source of our rights. Principle number two, the purpose of government. Again, back to the Declaration of Independence, that to secure these God-given rights, governments are instituted among men. So, principle two, the purpose of government is to preserve those God-given rights. Principle number three, the origin of the authority to govern. Back again to the Declaration of Independence, governments derive their just powers from the consent of the governed. So, the consent of the governed is required. And we must remember that the consent of the governed is obtained through the constitutional ratification process. Through the ratification process, the people agree to abide by laws created by trusted representatives within the limits and bounds which are constitutionally defined. The consent of the governed is not obtained through the elective process. That process only allows the people to select their representatives who will act within the constitutional limits already established constitutionally. So that brings us to principle number four. The authority to govern may be withdrawn. Again, back to the Declaration of Independence. Whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it. So the people retain the right to alter or abolish their government if it strays. The United States Constitution in Article 5 preserves that right. Therein we read, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as one or the other mode of ratification may be proposed by the Congress. No other constitutional means exist to change the Constitution. Of course, there are other ways to change it. They're not constitutional, but they could be done by violent overthrow. It could be attempted by legislative enactment. It could be attempted by judicial decree. It could be attempted by simply ignoring some principle or another. But the fact of the matter is that there is only one constitutional methodology of changing that Constitution, and that is by the constitutional amendment. George Washington reminded us of this in his farewell address. He said, the basis of our political systems is the right of the people to make and alter their constitutions of government. But when the Constitution at any time exists, till changed by an explicit and authentic act of the whole people, is sacredly obligatory upon all. So, that authentic act is an Article 5 Constitutional Convention, or by the means of both houses of the Congress bringing forth by 2/3 majority a proposed amendment and being ratified by the states. There are no other constitutional means by which this may be done. Washington went on to say in his farewell address, if, in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, note the word wrong. He didn't say if a difference of opinion or by some other means. He says if it's wrong, let it be corrected by an amendment in the way which the Constitution designates. But let there be no change by usurpation. For though this in one instance may be the instrument of good, it is the customary weapon by which free governments are destroyed. So don't just usurp it or change it by guess and by golly. Let's do the right way. Let's talk for a few minutes about constitutions. Noah Webster was one of the American founding fathers. He was in Philadelphia during the Constitutional Convention of 1787, although he did not attend, but he met regularly with many of the founding fathers. He wrote in 1828, or at least published, the American Dictionary, a comprehensive dictionary of the words that our nation used in its time of writing. The definitions he gave were the definitions that were used by the American founding fathers as they wrote their founding documents. So, if we look up Constitution, here's what we find. The established form of government in a state, kingdom, or country, a system of fundamental rules, principles, and ordinances for the government of a state or nation. In free states, the Constitution is paramount. What does paramount mean? Paramount means it takes precedence to, is superior to, and cannot be overridden by any other means. In fact, he goes on to say that. Paramount to the statutes or laws enacted by the legislature. It's superior to, takes precedence over the statutes or laws enacted by the legislature. Going on, limiting and controlling its power, meaning the legislature's power. And in the United States, the legislature is created and its powers designated by the Constitution. So the Constitution creates the legislature and it designates the powers that the legislature may have. Let's look at Principle 5, a written constitution. St. George Tucker, in my opinion, I always introduce him this way, is probably the preeminent constitutional scholar of the American founding era. A brilliant man. He was not at the Constitutional Convention of 1787 because he was indisposed, if you will. He was rewriting the entire code of Virginia single-handedly because he had been tasked with that responsibility inasmuch as Virginia was a state now in the United States and no longer a colony under the British Crown, and their laws needed to be brought up to date, if you will. So St. George Tucker had that kind of brilliant mind that he could do that all by himself. At any rate, St. George Tucker, writing about the Constitution, said, "It is a written contract. Government was reduced to its elements. Its object was defined, its principles ascertained, its powers limited and fixed." Sounds pretty definite, doesn't it? It doesn't have a lot of wiggle room in it. So, Principle 5, the written words of our Constitution have meaning. And those meanings may be known. They are considered a written binding contract, and a sacred oath is taken by all who hold office to live by that contract. Our Constitution is written. It's written in plain English. Those plain English words have meanings. Those meanings may be known. If by every logical stretch, the words may only mean what they meant in the day they were written. The American founders considered the Constitution to be a written, binding contract. If we allow the words of the Constitution to be redefined to meet modern agendas, those plain written words may be redefined to mean anything or nothing at all. The ultimate and end result will be the destruction of our magnificent Constitution. It could, by definitional drift, be amended out of existence without bothering to use the authentic process defined within the Constitution. That appears to be the desired approach being utilized by the universal assault on the fundamental form of our Constitution. British statesman William Gladstone was one of many that over the years have recognized the incredible, amazing Constitution that we have as a miracle that it mightily is. Of the United States Constitution, he wrote, "It is the most wonderful work ever struck off at a given time by the brain and purpose of man." It's interesting how so few today in our leadership positions understand and embrace that principle. But yet, 100 years ago, 150 years ago, it was so readily apparent to the rest of the world. Let's look at principle number 6, enumerated powers, listed powers. Enumerated means numbered, if you will. It's interesting that when the United States Constitution was brought forth, there were many who, in fact, Thomas Jefferson was one of them, that lamented the fact it didn't have a Bill of Rights. And that was a big sticking point for many. And those that had written the Constitution and gone through the process of arduously looking at the limiting the powers that it set forth in the Constitution, they argued, well, we haven't given the United States Constitution enough power to abuse any of your rights. And so to put it in a Bill of Rights would be dangerous, because in a legalistic sense, if you start listing things and you left something off, you left it off on purpose. And that's the danger. There is no way in the world that anybody could completely list all of our rights. And therein's the danger. If they left it off, someone may someday say, it's not there. You don't have that right. So after the back and forth discussion that occurred in regards to the government does not have enough power to take your rights. Oh yes, we still want a Bill of Rights. Oh yes, there's a danger if you try to list and don't list them all. Nevertheless, we still want a Bill of Rights. So went the argument. That argument and that danger was settled with the Ninth Amendment. The Ninth Amendment is an all-inclusive statement that says, even if we didn't mention a right, we still have it. It states the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So even though something is not specifically mentioned, we still retain that right, okay, as our individual God-given rights. Well, we come to the 10th Amendment. There was a clarification that they wanted to make for certain, that no one could ever say that the general government, the national government, had more power than was specifically expressed in the Constitution. So the 10th Amendment states, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Well, let's pause for a few moments to clarify and correct a dangerous error that many of our 10th Amendment advocates and some of our elected officials labor under. Some suppose that under authority granted by the 10th Amendment, the states hold essentially all authority to govern and do whatever their hearts desire. Nothing could be farther from the truth. The states and the general government and counties and municipalities and indeed all governments are constrained and bounded by the same overarching principles enunciated in the Declaration of Independence. We go back and read. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that to secure these rights, governments are instituted among men. Governments derive their just powers from the consent of the governed, and that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it. Note that these principles regarding government are not to be applied only to national or general governments. These principles apply regardless of the jurisdiction of the government we're speaking of. They apply to the general government, to a state government, to a county government, and to municipalities. God is the source of our rights. The purpose of government is to preserve those God-given rights. The consent of the governed is required, and the people retain the right to alter or abolish their governments. All levels of government must operate within those bounds. And remember that each state also has a constitution that defines and limits the actions of those who become our trusted representatives. And the consent of the governed to be governed within the limits and bounds defined within the Constitution, state or federal, is obtained through the ratification of that Constitution. And the trusted representatives take an oath to be bound to the limits defined within that Constitution and the United States Constitution. Those who hold office within the states may not govern outside those parameters, or they violate their sacred oaths of office. Let's go back and review again very quickly something that St. George Tucker said. In it, he quotes both the 10th and the 9th Amendments, reminding us of those. He said, the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, or reserved to the states respectively, or to the people. You'll remember that as the 10th Amendment. And still further, going on with Tucker, to guard the people against constructive usurpations and encroachments of their rights. By the way, constructive usurpations has to do with interpretations, how they hold their mouth and interpret or twist something. He says another article declares that the enumeration or the numbering or the listing of certain rights in the Constitution shall not be construed to deny or disparage others retained by the people. And you'll recognize that where it comes in our Bill of Rights. The sum of all, just summarizing what he said, which appears to be that the powers delegated to the federal government are in all cases to receive the most strict construction that the instrument will bear. So we interpret it as tightly as we can. There's no wiggle room where the rights of the state or the people, either collectively or individually, may be drawn into question. Let's go further with James Madison, who I believe is rightly called the father of the Constitution, and we could discuss that at great length. At any rate, in Federalist 45, he said the powers delegated by the proposed Constitution to the federal government are few and defined. They probably ought to be bolded and underlined. Few and defined, based upon the way we're running our government now. Those which are to remain in the state governments are numerous and indefinite. The former, meaning at the national level, will be exercised principally on external objects as war, peace, negotiation, and foreign commerce, with which last the power of taxation will for the most part be connected. Isn't that interesting? James Madison, at the beginning of this nation, perceived that the national government's delegated power to set up tariffs and impose taxes and duties such as that would be the principal source of our revenue. All of these other pickpocket methodologies that have come up since then seem to kind of just added to our burden of our people. But he thought most of the revenue required by the national government could be obtained through basically import taxes. Isn't that interesting? Anyway, going on, the powers reserved to the several states will extend to all objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state. So all of this other stuff that's happening in the national level against all of these other issues that are specifically mentioned in the 45th Federalist that belong in the state is encroachment. That's an interesting thought, isn't it? So, point 6, the powers granted to the general government are enumerated, spelled out, and limited. Principle number 7 deals with checks and balances. Again, going back to James Madison's brilliant logic, in Federalist 51, he said, the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist encroachments of the others. The provision for defense must in this, as in all other cases, be made commensurate with the danger of the attack. Ambition must be made to counteract ambition. The interests of the man must be connected with the constitutional rights of the place. So James Madison really considered it important that whoever held an office needed to hold that office and his position in that office as something that required their defensive action. If there was ever an encroachment, say for example by the executive to take over the legislative process by executive orders or through some executive department, the individual in the legislative had a responsibility to counteract that. The ambition of the executive to overstep the bounds of the proper constitutional authority must be counteracted by ambition of the legislator to hold sacred their responsibility and hold their power so that no one else could encroach upon it. These are simple, straightforward truths that have been long since abandoned in this nation, and because of it, our liberty is being encroached upon, as we shall see as we proceed here. So we need to recognize that even the powers of the courts may be restricted by the legislature. In Article 3, Section 2, Clause 2, we read the following. Now, we need to probably preface that statement with what happens in Article 3, Section 2, Clause 1. In that clause, the powers of the courts are enumerated, what the Supreme Court may do. And that's delegated specifically. So they have that constitutionally. But then it goes on in Clause 2 to say in all the other cases before mentioned, meaning those in Clause 1, the Supreme Court shall have appellate jurisdiction, so they can be appealed to, both as to law and fact. Then the important element that probably should be not only bolded and underlined and italicized, but engraved in the hearts of all those that are in the Congress, with such exceptions and under such regulations as the Congress shall make. So Congress has the constitutional authority, the right, and even the responsibility, as Madison noted previously, to protect against encroachment by that court. It does say that. They may make exceptions to what the courts may have jurisdiction over. And it's very interesting, except for what's in Article 3, Section 2, Clause 1, which they have constitutional authority that the Congress may not interfere with. So let's go to point 7. Constitutional checks and balances are intended to prevent the departments of the general government from usurping ungranted power. Principle 8 deals with the separation of powers, divided powers. It is interesting that there is no authority for any of the different departments to encroach upon the other departments. Let's review very quickly and carefully that the legislative has the power to make laws. Article 1, Section 1 specifically says that all legislative authority granted in the Constitution is held by the legislature, the House and the Senate. All. It's all inclusive. There is no other power whatsoever for any other organization at all, ever. I don't know how I can overemphasize that, to create law that will be enforced as law upon the people of this nation. And we find, particularly in this environment that we're in today, that the executive seems to think that by the stroke of a pen, he can create law that is binding upon the people. Executive orders can do no such thing. Neither can anything created within the executive branch under the departments they're in, whether it's the IRS, the EPA, the ATFE, OSHA, NIOSH, the FDA, anybody. None of them have the authority to create law that is enforced as such upon the people of this nation. All legislative authority granted in the Constitution is held by the legislative. They cannot do this. And later on in this presentation, we'll understand better the constitutional protocol in regards to those matters. The executive, on the other hand, has the power to carry out and enforce laws. The Supreme Court does not. And we could talk at length about how the Supreme Court is now basically harnessed the authority and power of the executive to carry out things that they enforce as laws that are not such. The judicial, on the other hand, has the power to judge in situations where the laws have been broken or when disagreements between citizens arise. It's human nature to seek, obtain, and then begin to abuse power. That's just the way it is. And by the way, that's exactly what the Constitution was written to prevent, as much as possible, with parchment chains, as has been referred to. You see, it's kind of a strange truism that people just want to grasp and then abuse power. And when people say that the Constitution's an old agrarian document, the horse and buggy days, and now we're in the space age and it doesn't apply, that's a totally fallacious reason. The United States Constitution has nothing whatsoever to do with technology. It has everything to do with human nature. And the American founding fathers were great students of human nature. They understood very clearly that nature to seek, obtain, and then abuse power. So they understood this thing. And while they understood it, other thinking individuals have also understood it. Lord Acton was a British statesman and philosopher. And 100 years after the United States Constitution was written in 1787, he stated, "Power corrupts, and absolute power corrupts absolutely." About 86 years before the Constitution Convention met, another English thinker, a guy by the name of Daniel Defoe, wrote, "All men would be tyrants if they could." And I think that's understood by almost all of us if we stop to think about it. And that was the principle that was to be controlled by the Constitution. Technology has nothing whatsoever to do with it. It has to do with human nature. So the founding fathers divided and subdivided power. Individuals have their inherent God-given sovereignty that is granted by nature of the fact that we are God's children, his creation placed upon the earth. Those individuals, in order to provide governance, delegated certain authorities and responsibilities to the states. Those states, in turn, delegated to a national or general or federal government, however people wish to use the term. And there is a more appropriate and proper way to do it, but we'll talk about that another time. The federal government, if you will, took those delegated powers under the hand of those that wrote the Constitution, and they divided and subdivided those powers even further so that they would not be likely to be abused. They again created that legislative branch that creates laws. They created the executive branch to carry out the laws, and the judicial branch to provide justice in the face of disagreement. So all entities retain and act within their specific jurisdiction, and they are not allowed to overreach or cross over into the other. And the founders made source, they were so concerned about the abuse of power that they even divided and subdivided the sources of power. That is so fascinating. It's interesting to me to recognize, and it should be perhaps to you also, that the House of Representatives has their source of power, the people, the voice of the people, if you will. The people elect directly those trusted representatives that are to go into House of Representatives and create law within the limits and bounds of the Constitution. That's been it from the beginning. By the way, that is one of the reasons the House of Representatives has such a short term of office, because they have so much power. The voice of the people is an incredible moving force if they get united. In addition to that, the House of Representatives has the power of the purse, meaning that they originate bills regarding money. But that's another reason why they've got a 2-year limit of office, because the most powerful office ought to be an office that is put up for election regularly to see if they keep themselves within the proper bounds. The states, on the other hand, elected or selected through their legislature the Senate. So the people had a place at the table in the House of Representatives. The states had a place at the table until the egregious 17th Amendment that happened against all logic, reason, and intelligence, and which threw out of balance a mighty separation of powers that the Founding Fathers had the foresight to create. The 17th Amendment allows the direct, no, it doesn't allow it, it forces it that way. The people directly elect their senators. So now, instead of the states having a seat at the table, the Senate has become a glorified house, in essence, with the voice of the people prevailing again. And that dynamic has utterly undermined the whole basis of our foundation of the nation. But until that 17th Amendment, the states had the seat at the table, and the Senate got its voice from the states, that power. The executive is another interesting dynamic. The people don't directly elect the president, and the states don't elect the president. It's a really unique kind of combination of states and people that create a unique single-purpose legislative body. That body, that legislative body, has one purpose and one purpose only, and that is to elect the President of the United States. And then it dissolves. It goes away. It's called the Electoral College. The president can no longer play to it. The president can no longer leverage it in any way to get certain things the executive would like to have. It comes into existence for one purpose and one purpose only, and then goes away. That Electoral College is under direct assault and attack in today's world, and there is a tremendous effort to get rid of that also. We talked about how the power or voice of the people goes into the House of Representatives, and that is something that is very powerful. The Senate used to have their power from the states. That has been changed by the 17th Amendment. Now it's the voice of the people again. And where they're trying to put this now is to have the president elected by the voice of the people. And what that will do is countermand all of the careful checks and balances and separations of power that were placed in effect by the American Founding Fathers to prevent human nature from overcoming the parchment chains that they had established and running amok and becoming more and more and more like a democracy. The more we become like a democracy, the closer we are to communism. In fact, Marx said that, and Stalin said it, Lenin said it, Mao said it, and Woodrow Wilson said it, basically. We're moving in that direction tremendously now, and if we lose the Electoral College, it will be a tragic time for this nation. Well, the judiciary is created by the executive and the legislative sharing the power of appointment. But as we pointed out already in Article 3, Section 2, Clause 2, the legislative can limit the court's jurisdiction. So what Jefferson said in Questions of Power then, let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution. That was his hope, was that we could no longer just say, this is a good guy. Let's just kind of shovel the authority and power upon him, and he'll do the right thing with it. There's a lot of voices today that are attempting to do that, but no, we need to be bound by the Constitution. And Madison, again, in his brilliance in Federalist 47 said, the accumulation of all powers, legislative, executive, and judiciary, in the same hands, whether of one, a few, or many, and whether a hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. And therein we find a great and terrible problem for this nation. So often today, the executive creates the law, the executive adjudicates the law, and the executive enforces the law. And as Madison said, therein is what is found as true tyranny. Thomas Jefferson worried that ultimately all power would be usurped by the general government and tyranny would result. He said, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief, over the field of jurisdiction until all shall be usurped from the states, and the government of all be consolidated into one. To this I'm opposed, because when all government, domestic and foreign, in little as in great things, shall be drawn to Washington as the center of all power, it will render powerless the checks provided of one government on another, and will become as venal and oppressive as the government from which we separated. See, therein lies the problem. It's not just a problem. It is something that we're well on our way to having happen in the United States. And we need to guard against that. So the Constitution clearly separates and divides the power granted to the general government to guard against tyranny. Principle number 9, delegated powers may not be redelegated once granted by the people through the constitutional process. Let's speak just very briefly about John Locke. In so many ways, John Locke can be considered a mentor of the American founding fathers, although he had left the mortal scene prior to them in their ascendancy. But they all read his documents. They carefully reviewed his wisdom, and he understood and outlined very, very succinctly constitutional protocol in so many instances. In his second essay, John Locke wrote, the legislative cannot transfer the power of making laws to any other hands, for it being but a delegated power from the people, they who have it cannot pass it over to others. The people alone can appoint the form of commonwealth, which is by constituting the legislative, and by appointing in whose hands that shall be. And when the people have said, we will submit and be governed by laws made by such men and in such forms, nobody else can say other men shall make laws for them. Nor can they be bound by any laws but such as are enacted by those whom they have chosen and authorized to make laws for them. Isn't that interesting? Nobody can say, not even the legislature can say, I'm delegating to the executive the power to create law. Now, think for a moment. If in fact the legislature did say to the executive, oh, when you have this new department we're creating, the EPA or the IRS or the BATFE, they can create law that will be enforced against the people. That cannot be done. Protocol of constitutions do not allow that. You cannot say, oh, we're creating a treaty that will now delegate to a foreign power, whether or that treaty power, that we will be called to war without following the Constitution. A treaty cannot do that. A foreign trade agreement, such as the USMCA, the United States-Canada-Mexico agreement, cannot say we are creating the power of this unelected body of 3 national delegates to be able to create our trade law. It cannot be done. It cannot be redelegated. That is constitutional protocol that was well understood by the American founding fathers, and which today we violate at all times. The executive creates law by executive order. The departments in the executive branch create law that's enforced as though it were law upon us. It's not really law, it's pretended law. And certainly those foreign agreements, whether they be trade agreements or whether they be treaties, are often used to violate what is constitutionally delegated and may not be redelegated. It's interesting to me that Thomas Jefferson agreed with John Locke. He said, "Our ancient laws expressly declare that those who are but delegates themselves shall not delegate to others powers which require judgment and integrity in their exercise. Necessities which dissolve a government." So he says, even if a point comes that the government is dissolved, goes away, do not convey its authority to an oligarchy or a monarchy. They throw back into the hands of the people the powers they had delegated and leave them as individuals to shift for themselves. A leader may offer, but not impose himself, nor be imposed on them. The powers of the people are sacred, and once delegated, they may not be redelegated, nor may they be usurped by someone else. Again, our good friend St. George Tucker is very succinct in the way he defines these issues. He says a delegated authority cannot be transferred to another to exercise. This is something that has slipped through our fingers and is threatening the very existence of our nation. The powers constitutionally delegated by the people to the general government may not be redelegated by those to whom they are delegated. The United States Constitution embodies and preserves these foundational principles. The United States Constitution is by conscious design a republic. The Republican government established under the principles of the United States Constitution allows liberty and proper government to thrive when those principles are upheld, sustained, and abided in. Perhaps we should spend a few moments focusing on the concepts of our republic, and that will hopefully reinforce the importance of our republic and the preservation of our liberty and proper government. Let's again look to our old friend Noah Webster. He defined republic thus: a state in which the exercise of the sovereign power is lodged in representatives elected by the people. In modern usage, it differs from a democracy or a democratic state in which the people exercise the powers of sovereignty in person. So let's just talk about republic for just a moment or two. The basis of our republic is law. The law applies to all. The law is limited to a specific scope. The law protects all equally. It is a representative form of government. Our trusted representatives may only exercise or create laws within the bounds of authority delegated to them by the United States Constitution. The United States Constitution itself is a written binding contract. Within the Constitution, the limits of government are defined. Within the Constitution, the powers of government are enumerated. Checks and balances are firmly established. Can you see how all of these things within our Constitution are following these baseline principles that allow us to have proper government and liberty? The powers of government are separated, divided, and subdivided, and all individuals and agencies within the government are to operate within the bounds established in the nation's charter, the United States Constitution. This was by design from the beginning. Every step which brought forth this nation followed and embraced Republican principles. The United States was a republic from the foundation. Every step taken in the founding and establishment of the government of this land was taken in conformance with Republican principles. Democracy was not the driving principle of the foundation ever, at any time, as this nation was brought forth. Let's examine that briefly, and it'll just be very briefly and with hopefully succinct points, so that you'll be able to see, again, this is a republic from the foundation, taken from the beginning. The representatives of the people in the states met in 1776 to determine the course of the nation. Those trusted representatives declared the nation's independence. It was not a democratic action. When the 1787 Constitution Convention met, the delegates to the convention were the duly appointed representatives of the people in the states. The delegates were not democratically elected to their representative positions. They were appointed within their states by the trusted representatives that had previously been selected by the people. And when the delegates to the convention gathered in Philadelphia in May of 1787, one of the first orders of business was to clarify why they had gathered. In May 31st to be exact, Edmund Randolph, a delegate from Virginia, got up and helped remind the convention why they were there. He said the purpose of the convention was to provide a cure for the evils under which the United States labored. That in tracing these evils to their origin, every man had found in the turbulence and follies of democracy. There was never at any point, ever, an inference that what they were creating or to create in that convention was to be a democracy. And in fact, to me, it's very interesting that the Federalist Papers, which were written to convince the nation to ratify the Constitution, began in the Federalist Paper number 1. There's 85 Federalist Papers. Hamilton wrote the first one, he wrote the last one, he wrote a lot in between. But in the first one, he says, if we do not prove that this Constitution that we put forth is a republic, you need to reject it. In the 85th Federalist Paper, he reiterated that point. And in numerous instances, written by also Jay and Hamilton in the middle, Jay and Madison, they reiterated the Republican form of government. The national government created under the Constitution is a Republican form of government. And Article 4 of the US Constitution requires each state which enters into the Union to be governed under a Republican form of government. The Constitution is originally established, and I know we've strayed far from it, is granted power to operate within a limited scope and bounds. The national government only had specific enumerated powers, beyond which it had no authority whatsoever to operate. And the representatives that are sent into that government are empowered only to do what they're delegated. They are not empowered to exceed the powers granted them. And by that means, we're to protect our liberty, our proper government, and our individual God-given rights. But let's go on with this idea of a republic from the foundation. The United States House was elected democratically by the people to be their trusted representatives in the government. The US Senate was, prior to the 17th Amendment, appointed by the legislatures of the states. And the legislatures of the states are representative bodies also, they're republics. And the Senate, representatives of representatives, were to temper and keep the democratically elected House within proper bounds. They were to temper that democracy idea that the House might bring to their office. And the ratification for the new Constitution never included any elements of democracy. The proposed Constitution first went before the United States Congress. That's where the convention forwarded it to, which, again, the Congress is duly elected representatives of the people, not the people themselves. After it had been sent to the Congress, it was presented before conventions of delegates within each state who were chosen by trusted representatives of the people who had been selected by the people under the recommendation of the respective legislatures of each state, again, representatives of the people, not the people directly. So it went from the convention to the representatives of the nation to the representatives of the states and the people. Isn't that an interesting phenomenon? Wherein the people were not to be democratically involved in this thing. Let's go to the amendment process. The amendment process defined with Article 5 of the Constitution is also a very Republican in its form. 2/3 of the representatives of the people in the states, as in the House and the Senate, are to propose amendments. 3/4 of the states ratify the proposed amendment through either their state legislative representatives or through representative delegates to state conventions. the process does not at any time democratically put the matter before the body of the people for their approval or disapproval. The Declaration of Independence notes that when any form of government becomes destructive of its proper purpose of securing God-given rights, it is the right of the people to alter or abolish it. That right, as we've noted, is contained in Article 5 of the United States Constitution. It was written specifically to allow such an option to remain within the sacred rights and obligations of the people. But as we examine the Article 5 amendment process, it allows trusted representatives to modify the Constitution and never a democracy. Faithfully observing these foundational Republican principles is essential to preserving the nation, our liberty, and our proper government. Well, we've come to the point where we ought to summarize. God is the source of our rights. The purpose of government is to preserve those God-given rights. The consent of the governed is required. The people retain the right to alter or abolish their government. The written words of our Constitution have meaning, and those meanings may be known. They are considered a written binding contract, and a sacred oath is taken by all who hold office to live by that contract. The powers granted to the general government are enumerated, spelled out and limited. Constitutional checks and balances are intended to prevent the departments of the national government from usurping ungranted power. The Constitution clearly separates and divides the power granted to the general government to guard against tyranny. The powers constitutionally delegated by the people to the general government may not be redelegated by those to whom they are delegated. So there we have it. 9 essential elements that are enumerated and expressed by the American founding fathers in an effort to preserve our constitutional God-given rights. These principles, applied under Republican form of government and administered by trusted representatives who unerringly abide by their oath to keep their actions within the bounds and limits established under the Constitution, will be the pillars safeguarding the nation's liberty. When these principles are being ignored or violated, tyranny is being implemented upon the nation. It's interesting that Thomas Jefferson recognized that single acts of tyranny may be ascribed to the accidental opinion of a day, but a series of oppressions begun at a distinguished period and pursued unalterably through every change of ministers too plainly prove a deliberate, systematical plan of reducing us to slavery. I would submit that the many acts of tyranny that are being set forth today in the United States may not be ascribed to an accidental opinion of the day, but rather they are continued through each change of ministers and unalterably proves a systematical plan of reducing us to slavery. Americans today really need to become aware of what is being stolen from them by those that sit in high office. And we need to come to the point where we act with great vigor to resist every act of tyranny and seek to preserve the blessings of liberty and of proper government for ourselves and our posterity. Thanks for caring about these great and wonderful principles. Appreciate your time.